To sue or not to sue? That's the question. I'm here today with Anton Kaminsky from Kaminsky Law. I assume your answer is going to be sue always and often, but as an attorney. But in all seriousness, Anton, to sue or not to sue, when this affects a lot of business owners, what do we need to know?
90% of the time, my answer is don't sue.
Wow. Okay.
It really is. It's either don't sue or really think carefully before you sue. And there's a couple of questions you should ask yourself before you considering whether or not to sue. One of them is, what are my damages? The next one is, how much am I willing to spend on this? And along the lines of how much am I willing to spend on this, you should think not just about money, but about time and, stress and peace of mind. And then, the other question is to really balance, and it's maybe not a question, but you should be balancing, am I throwing good money after bad?
So Anton, hearing that though, I know your firm your philosophy has always been to be aggressive on behalf of your client, to be an aggressive advocate, right? And versus some that might always be looking to settle. And how does this reconcile with that sort of legal philosophy?
Well, we are aggressive, and that is a philosophy, aggressive, once we get started. But what I'm trying to kind of take this back to is, do you really need to do this, right? Do you need to go there? And should you go there? And is it a good decision? Because we get so many people that call us. They're usually emotional, very emotional. Somebody ripped me off. I'm going to punish them, right? And there's a saying that principle doesn't pay principle, right?
Sure.
And, we have to win as a matter of principle. I got to hurt this guy. And I've been in situations as a lawyer now so many times where you'll spend more money than you're out trying to get back the money that you're out. And now you hate the lawyer. You're like, well,
right.
You screwed me. And it's like, well, no, I didn't. I tried to talk you out of this on day one.
So what does that sort of look like? Because I think that there's two philosophies, right? There's that emotional, angry, I want, revenge, right? And then there's the folks that avoid anything that's going to look like a lawsuit no matter what, right? They're tiptoeing around, right?
Yeah.
And so walk me through the balancing act of what maybe is happening before people are coming into your office, right? And where it's either too early or too late.
Sure. And I think that in order to do that, we even have to back up a little bit.
Okay.
All right. So let's talk about Pennsylvania specifically, because in Pennsylvania, there's 3 sets of courts. Well, there's more than 3 sets of courts, but the ones that I want to focus on right now are 3 sets. There is the municipal court, which handles what are called small claims. So that's everything under $12,000. Then there is the it's called compulsory arbitration or mandatory arbitration. And that handles everything that's between $12,000 and $50,000. And then there's the Court of Common Pleas, which handles everything that's above $50,000, right? And that's your initial court. There's the appeals. There's all sorts of, you can go to voluntary arbitration, which isn't done by the courts. You could go to mediation, but just for the sake of
this conversation, we're focusing on these 3.
Yeah, let's focus on these 3. And so the first question I'm really asking you is, what are your damages? And when people tell me what their damages are, you also have to separate that, because let's just say you have a contract, right? And I have a contract, you're going to build my backyard out for $100,000, and you do that in a screwed up way. And I've paid you, $50,000. You think you're owed $50,000. I think I shouldn't have to pay you the $50,000. Let's just say, for the sake of argument, I'm in the highest level court, which is the Court of Common Pleas. I don't have to go to arbitration. It's not small claims. It's the court.
Okay.
If you call me and you say, this has taken an emotional toll on me, I haven't been able to sleep. Think about all the times that I had to come home from work to yell at these contractors.
I think I see where this is going, yeah.
Right? My damages are $2 million. I'm going to laugh at you, right? Maybe I won't laugh at you, but I'm going to tell you that you're not going to recover that,
sure.
Right? So if you have a contract, then your damages are typically, confined by the contract and what the damages could have been arising from this contract, right?
So just to ask on that point though, because I think that a lot of folks, the emotional damage, and mental health is a huge topic these days, right? So Are the courts more forgiving in that area, less forgiving? Are they more strict to the contract? When would that sort of like mental health, damage come in? Does it mean that like, does something else have to happen? Meaning like I was doing all these phone calls, I'm dealing with all this stuff, and then I lost my job because I was focusing on my backyard, right? And now I can prove damages? Like, does it have to be something else that adds to it?
Sure. And the way that you just said it, right? I was focusing on my backyard and I lost my job or I missed work. Maybe that is a damage, right? But the emotional distress that you got from fixing up your backyard, no one's going to award you. So you have to almost, when you're thinking about this in the beginning, again, before you even go to a lawyer, you should put yourself into the shoes of a judge or a jury person that's going to hear your case at the end. And it's like, I didn't pay this contractor 20 grand because I couldn't sleep at night, and now he owes me $1 million. It's like, okay.
So it's a little bit of, I guess step one is take a breath. Step two is when you're in a less emotional state, and I love that idea. Step three, put yourself in the shoe of a mediator, right? Not necessarily the person you have a grievance with, but just like if somebody as a third party was listening to this, what would they most likely say? And that probably is going to give you a good sense of direction of where to go next.
Absolutely. And the thing is, you said there's things that rise to the level of emotional damages, right? So if something happens to you that is an injury, it's different than a monetary injury. So there's, the injury to you as a person versus the injury to property or to, something that you own. I mean, property is a good way to describe it. And courts typically separate contractual damages from tort-based damages, right? Okay. So contractual is obvious. It arises out of a contract. Tort is like arises out of a duty that somebody owes you, right? So I have a duty to not punch you in the face. If I punch you in the face and you are then harmed, I've done something that is a tort to you.
So
right?
let's take a step back from the MMA example and go into this is like UFC world. We just fell into the cage by accident. Go back to our backyard contractor, right? So the contract is, hey, do the backyard. Didn't do it right, did do it right. That's the contract part. What would be an example in that scenario, other than a face punch, of a tort situation? Or is it not applicable?
Well, it is, let's talk about what could turn that into a tort short of a MMA fight. For instance, the contractor could just steal your money, right? Okay. And do no work. Let's just say you paid them a bunch of money, they took your money, they didn't show up, or they stopped showing up, whatever it is. Or let's say you paid the whole $100 grand of our example, right? And then he stopped doing work after 10 grand.
What about something less clear? I wanted, oversized boulders in the backyard as a decorative, and either he brought the wrong material or a faux boulder. Like, does that apply?
Falls under contract.
That falls under the contract. Okay, so
think about it this way: if the duty that you are worried about, or the duty that you're thinking about suing about, arises from your agreement with this person, it most likely goes under the contract.
Okay.
If the duty arises from something that is separate and apart from the contract, then it would be a tort. So I'll give you a good example that's not as clear cut, right? Let's say you're somebody that has a good reputation in your community, in your church, in your synagogue, wherever you go. You have high standing. You participate in the PTA or whatever it may be, right? And now you enter into a contract with a guy that's going to do your backyard. You don't pay him some amount of money, and then he goes around and starts telling people that, you're cheating on your wife, and he saw this or that happen, and he's saying that you're, a criminal of some sort. So that would fall under, the defamation, the libel, the slander type of tort.
Uh-huh.
And that would be completely separate and apart from your contract, right? So I owed this guy money, and now he went and slandered my name in the streets.
So I like the way you said "in the streets" there. In the streets. But I just to go back to that really quick, if the defaming comes from within the terms of the contract, meaning the grievance you just mentioned was you owe him some money, you guys are having a disagreement, and the examples you gave of him defaming you are tangential to that. But what if he was running around and going like, you're not a good, this person's not a good person because they owe me money, right? Is that's still tort because it's like taking outside of the agreement and you're defaming, or is it
that's where you start getting to the gray line?
Interesting.
Right?
Okay.
Well, first of all, and I don't want this to turn into a conversation about defamation. We
Of
could
course.
do a
Yeah.
whole separate video,
And we should.
But the defense to defamation is truth, right? So if I owe you $50,000 and you're going around telling people that I owe you $50,000, I could try to sue you for defamation because people sue for any reason and no reason. But you could show up and say, "Hey, Anton owes me $50,000. It's not
and
defamation."
you can do.
Right. But if you say it's one thing, I say another thing, and it still arises from the contract, I mean, you can now arguably bring a second claim. It's defamation, right? You say I owe you 50, I say I owe you 20, you're lying. It's a little.
It gets really gray. Okay.
It's not that it's gray. It's just it's still tenuous. Like if you came to me and said that, and I want to sue for defamation, I'd still shake my head at you. Hey everyone, sorry for the interruption. If you found this information helpful or useful, please take a moment to like, share, and subscribe so that we could keep producing content and so that you get notifications next time there's an episode.
All right. Thanks, Anton from Kaminsky Law, and back to the episode. I want to take one step back before, I feel like we're taking two steps back before one step forward, but I have one more question before we get into your example that folks might want to know. When you were doing the analysis on which tier we were going to be in, you'd sort of use the example that I think the backyard, if I remember correctly, cost $100,000. There was a $50,000 delta that we were disagreeing over. And then you had said that was going to put us into the sort of the courts, like the top courts. Mm-hmm. Is it based on the gross number that the contract is defined by, or is it based on the delta, right? So meaning the contract was $100,000. We're arguing over 12 of that 100. Am I in that lower court at this point, or am I going to the upper? Does it matter to me? Do I just go to the attorney and ask? But is it something that I should know ahead of time?
Well, and let's reframe that a little bit.
Okay.
So to answer your question quickly and briefly, whoever's filing the lawsuit says what their damages are, and if they say that their damages are over $50,000, it just by default goes into that other court.
Okay.
Okay. But let's rewind, like you said, and talk about it for a second. So the reason that I was bringing this whole conversation up of to sue or not to sue is that under $12,000, you can cap your damages and say, right, I'm going to go, let's say you owe me $14,000. Okay. And if we're suing over $14,000, we're going into arbitration. It's more of a intensive process than small claims courts. If you're going to rank the courts in easiest and cheapest, it goes small claims because you're just filling out one piece of paper and filing it.
Got it.
To arbitration because you're filing a complaint still. You might do some limited discovery, and then you're going to get a hearing date within a year. And to the most expensive being the Court of Common Pleas, because that's, full-on lawyers. You're doing the whole process. And so if you have, let's say, a claim for $14,000, it might be wise to say, I'm only going to sue for $12,000. I'm going to agree to limit my damages to $12,000 because then I can go to a small claims court, fill out a one sheet of paper document, say, this is what my gripe is, file it, spend the few $100s that it costs to file it, and then you get a hearing date in a few months. And then you show up, you argue your position, you don't need a lawyer, and you could be done.
So even if you're above that threshold but close, that may be a better calculation of how to go after your money.
And that's a conversation I'm having a lot of times because as a lawyer, I don't want to take your money if you're suing for $12,000, $15,000 because you might have to pay me $5,000 to $10,000.
Sure.
So what's the point of paying me $10,000 to go maybe win 12?
Right. That doesn't make sense.
And you're going to hate me.
Yeah. Right. And that, you've said that a couple of times. So I think that, is there a way to set the expectation for folks that maybe either are about to approach a situation or came out of a situation? They're like, man, this attorney was the worst. And sort of set the ground rules of, hey, these are things that you could be upset about, right? Like, but these are the areas where if your attorney's advising you in a certain direction, then you're going against it, it's really unreasonable to turn around later and go, I can't believe you charged me so much for the advice that you told me not to take.
Unfortunately, we see that so much. So now I just try to just say no to those people, right? Because I just say, okay, I could tell now you're not going to listen to me or you're going to hate me later. So I'm just not going to do it. And a good way to, the ground rule for this, or a good way to think about it is this. You go to a law firm, sometimes people, somebody ripped you off for 20 grand. Let's just say 20 grand's like kind of like right there you don't want to go to the small claims court because then you're foregoing half of it, right? And it's still, it's still not such a big number that you're like, I'm suing no matter what. And, I don't care how much this costs.
Sure.
And so somebody screwed you for 20 grand and you show up and you're going, I'm going to get the most expensive lawyer to, really step on your neck and that,
Right.
You should think about that, because if you're suing for 20 grand, what is a reasonable amount of money to spend to collect it? Is it 25%? Is it 50%? Is it 30%? And so if you're going to spend more than $5,000 to $7,000 trying to collect $20,000, you're going to be unhappy if you win.
Right.
If you lose, you're going to be really unhappy, right? And lawsuits aren't guaranteed. The judges might not agree with you, or the jury might not believe you, or whatever it may be. Or the other side, we could have a whole separate conversation about what happens when people just appeal for no reason.
Right.
And that's just an added expense. I appeal. I disagree. I appeal. Right. And
now it just keeps going and going.
Well,
and
now
going.
you're along for the ride. Now it's like the, what's that movie where he's like, now you can't leave.
Right. Oh, that's one of my favorites, actually.
Bronx Tale.
Yeah, Bronx Tale. I use that all the
now
time.
you can't leave.
Yeah.
Right.
First I asked you to leave. Now you can't leave.
And that's what happens, because when, you go to a small claims court and you win, somebody might just say, you know what, I want to be done with this. I'll pay you. Or they might want to be difficult and they say, I'm appealing. Now you got to take it to the next level.
And now it keeps going. Let me ask you that while we're here. And I assume it's just a standard business analysis and something that you would need to decide. But is there an analysis that you use when you're deciding, percentage wise, what's worth it to go after, right? So you use the $20,000 example. You said it might cost you 5 to 7 to get it, right?
So this is the analysis I use mentally. I try to not take on cases if people are fighting over less than $50,000 to $100,000.
Okay.
If somebody's adamant about us representing them on a smaller case, what I'll do is I'll typically say one of our associates will handle it with our oversight, but that's going to try to keep your costs low because their hourly rate's low. And then if they spend 5 hours on something versus me spending 5 hours on something, it's almost double, right? Or me spending is double than what they're going to spend, almost. And so, that's a great training tool for younger associates, is to do some of these smaller cases. But what winds up happening oftentimes is people come to me and say, Anton, I only want you, right? I only trust you. I want you to be there. It's like, okay, I get it. And I'll be there if you want me to, but juice isn't worth the squeeze here. And I'll try to, I don't want to say talk people out of it, but I try to give people kind of a lay of the land of what could happen before we get started, so that they could be real about their damages, which is the first thing we said. Because if you think you're going to recover $1 million in a $20,000 case, it's just not going to happen. So maybe in your mind, you spending $20,000 because you think you're going to recover $1 million is fair.
Right.
In my mind, I know that you're, capped at recovering $20,000, so I don't want you to spend $20,000.
Of course.
And then the second piece of it is, how likely is it to recover, and how difficult of a process is it? Because, and that's another thing we haven't talked about, and we can kind of get into it. But for instance, do you have an agreement, a written one, or do you not have an agreement? Does your agreement say that the winner is going to be able to recover their attorney's fees, or doesn't it?
Right.
And we've talked about these kinds of contractual things, but when you're a lawyer taking in the case for the first time, or when you are, putting myself into your shoes, when you're the potential client trying to pitch your case to a lawyer, some of these things are very important, because if you have a provision that says, if I win, I'm going to recover my attorney's fees, that's a hammer that I can use to try to get somebody to settle.
Right.
Because, hey, we're both going to spend money on this, but then you're going to have to pay back my money after the fact. So why don't you be reasonable now?
And let's figure this out together. And now that discovery process, I don't know if that's the proper term. I know discovery is a term in the legal space, but I'm using it in the context of just vetting the case, really, right? Vetting if this is the right, if they're coming with a small claims situation, and are at Kaminsky law, is that something you charge for to figure that out and do that vetting? Or is that something that is part of the process before you take on the case? Because it sounds like a lot of work. There's, hey, do you have this agreement? Let me review it. What happened? What are you claiming as damages? Why are you claiming those damages? It's not like a bulleted checklist where you can just go, yes, it's a conversation. So what does that look like?
That's a process that we have set up at Kaminsky Law. What will wind up happening usually is you'll call our office, you'll talk to one of our paralegals or one of the junior lawyers. They will typically ask you the general information that we need to have to review your case. So if you tell us you're suing because of a contract, we want to see the contract. If you're telling us you want to sue because somebody posted, something mean about you online, do you have a screenshot? If you're a shareholder trying to do a shareholder dispute, show us your operating agreement, show us some of the back and forth that you've had to date, what's happened. And so we basically intake that information, and I could do a whole separate video about how people hate giving us that information to anyone except for the lawyer that's going to be reviewing it. But you have to work with us because it is a screening process. And so what we'll do once we have that is one of the more senior lawyers will look at it. We'll see if that's something that we can help with. If it's something that we can help with, great. We'll schedule a call, and then we'll have a call and kind of go through it in more detail. If it's something that we can't help with, we usually try to tell people right off the bat so that they don't spend too much time or effort talking to us. Maybe they need to talk to somebody else. Maybe we could refer them to somebody else. And so if you're a person that's looking for a lawyer, you really should kind of have some sort of summary ready to go. Maybe some bullet points, maybe whatever relevant documents you have. One of the hardest things for us as lawyers is we'll get people that, they're emotionally attached to their case.
Sure.
And they're sending us, a 10-page timeline and, a 50-page analysis of a 3-page contract. And they're like, did you review what I sent you? And it's like, I didn't before our call. I was kind of hoping that you would tell me.
Right. In a condensed way.
Right.
If I'm pursuing this process, I'm looking to talk to an attorney. Is there an in-between with option A, I won't talk to anybody until it's the attorney and I don't have anything ready? Or option B, I have the George R.R. Martin version of my case. Like it's, the Game of Thrones of stories
of a $20,000 lawsuit.
Right. And I need you to read it within the next week, or else. What's like maybe the top 3 or top 5 considerations, bullet points I need to have for the attorney to properly be able to vet my case?
It's hard to say this on a general basis because so many different types of lawsuits are different. But what we tell people is give us the facts that move the needle. If you had to explain your story to somebody in an elevator, right? People talk about elevator business pitches all the time. If you had an elevator business pitch your story to a lawyer, what are the 3 worst facts for them or the 3 best facts for you? What are the 1 or 2 most important documents that pertain to this? Is it emails? Is it an agreement? And what's happened so far? That's really all we need to know for the most part to screen your case.
I think that's so helpful because a lot of times we don't, like when you said the first point was, bring up the most important points. I know for situations I've had in the past, I don't know what the most important points. Like I think of the Perry Masons of the, you're going to listen to my story and you're going to find Article B, Section 5. I can't believe he said that to you. That's an infringement on da da da. But that's not the reality of how the law works. It really is those main bullet points of, and you walk us through, you'll do a better job than I will, but we had an agreement. This is what the agreement was for. So far, the work isn't done. We'll use the backyard guy, right? We signed an agreement for $100,000. He did $50,000 of the work. The work isn't satisfactory. He's not coming back. I'm not paying him, and we're stuck. That's a pretty short. Is that a good example?
That's a great example. And we have conversations. I don't want to put anybody on the spot, obviously, but you'll have conversations with potential clients. And, for instance, in a shareholder dispute, hey, he's spending the corporate credit card on things that are unauthorized. And I'm like, okay, tell me about some of them. He's filling up gas at the gas station. Okay. What else? He bought food at Giant. Okay, what else? And then they'll kind of stop, and you'll say, okay, well, how much is that a month? $100, $200. And I'm like, all right, are we going to sue over $200 a month? Is it that bad?
Right.
Or did the person buy a Rolex on the company credit card? Right. And it's like, if the person bought a Rolex on the company credit card, it really doesn't matter that they're filling up gas and going to Giant on the company credit card also.
Because that's the thing that's going to be
the thing that's
egregious.
important is the Rolex. Right?
Now, is that because of the value, the amount of, is it the amount of dollars, or is it how, I'm looking for the word here, but just how egregious the purchase is? Meaning, like gas, you could argue maybe I needed for business or it was a mistake. Groceries, it was for a party we were having at the company. Unless you're doing somebody's retirement gift, right? In which case you're not keeping that Rolex. If you're buying a Rolex on the company dime, you got, Lucy, you got some explaining to do, right? That's great minds. We're finishing each other's sandwiches. So yeah, take us
Great
back
song.
there. Yeah, great song. So take us back there. So what's the takeaway, right? If I'm doing the analysis, I should do what?
When I say things that move the needle, right? When you hear somebody went to Giant or to Wawa or to the gas station and filled up or spent money and it's a small number, it doesn't jump out at you and you immediately have 5 things it could have been. Hey, maybe I stopped at Wawa for lunch, or maybe I stopped at Giant and got a sandwich to go, or whatever it may be, right? A Rolex really has very few explanations. And so there's certain things that you'll have that jump out at you on a business statement or on a bank statement. And so if you're going to pitch a case to a lawyer, which is what we're really talking about here,
Sure.
You want to lead with the things that move the needle that really jump out at you.
So I think that's probably a good place to pause in this episode. And I think we've got a lot of great content here on when to sue and when not to sue. And I think a lot of it comes down to, again, taking a breath, taking an emotionless approach to analyzing your case, imagining a third party was looking at this. What are the things that they're going to see that move the needle, right? That are egregious, that clearly show that there's actual damages, and those damages have to be real, quantifiable damages in order for realistically a case to process. And I think in the end too, looking at the tier of damages you're going for and having a realistic estimation of what's the right approach to get that money. You're not going to spend $50,000 to get 12. So if you're doing that analysis across the board, whether it's the small claims, the arbitration, or court of common pleas, you really want to make sure that you are doing a proper analysis of where you're probably going to fall, what moves the needle, and how much you're realistically going to spend to get that money.
Yeah, and I couldn't have said it better myself. I think that when you're thinking about whether or not to sue, that really should be your first analysis. You should be thinking about how much am I willing to fork out and how much am I realistically going to get back? And, I don't want to become a, math scientist here, but you also should take into account everybody thinks that they're going to win their case, but
Right.
You could also not win. And so, there's a possibility that you don't win, and there's a possibility that you spend money and you still lose.
Yeah, factoring that probability, right? So that's the other thing we missed is, you also have to calculate that probability that you may lose or you may win, and they will appeal that they're not doing the same analysis financially. That does this make sense to continue to pursue? Yeah.
And you just raised another thing in my mind that I probably should have said in the beginning, but it reminded me of it. Sometimes you can also win and have nowhere to collect from. And that's almost as bad as losing, because you have this victory, but it's not really worth the paper it's printed on. And so that's another analysis we do as lawyers. That's another analysis you can do on when you're deciding whether or not to sue. Let me give you a couple of examples.
Sure.
So when you're suing a huge corporation, chances are if they lose, they're going to pay. Those corporations are more likely to settle a case because they know that if they lose, it's, maybe it'll be public, maybe it'll be a bigger number. So they're more likely to settle the case. They also take a much more business approach to it. They're also thinking about how much am I going to spend defending this thing, and factor that into
They're
whether
not getting emotional. They're
Right.
being strategic.
Right. So when you're suing a business and you're suing, a viable business, let's call it, one that is still making money, it's an easier decision of whether or not to sue, leaning towards yes. when you're thinking about suing that contractor that you think might be on drugs that stopped showing up with and took your 12 grand, yeah, we could sue him. We might never be able to find him. And even if we find him and you get a judgment against him, he might not have a penny to pay you back from. And so even if you win, you still lose.
So, but are you saying that there is no value? Because I will say that there's a little bit of the, ironically, going back to emotions, the emotional value of going, I've gotten a judgment against this person and I know that's going to follow them. And maybe that was at least the goal. Like, yes, I'd want my money back. I know I'm not going to get my money back, but I want to at least have done something to make sure this person can't keep doing this to others. To that extent, what is your opinion on judgments and the value, how to value a judgment against, another party?
Excellent question. And there's a lot of thought process that goes into that. So let's just tie this back to the beginning, because I'm raising the question of, is this person someone we can collect money from, for the analysis that you should be doing of to sue or not to sue. Okay, so if the person is not somebody you can collect money from, that's just another mark on the not sue. And so yes, you can sue somebody on principle, and I've seen it, I've done it, I've been there, especially on larger numbers, right? Maybe you might not sue somebody on principle for $5,000. For some people, it's a lot of money, but you might want to sue somebody on principle for $500,000.
Right.
And to make sure this person never does it again. And so I'm just talking about collectability from what category are we putting this into? But to your point on collecting on judgments, yeah, there's a lot of ways that you can collect on judgments. We personally don't do it. We usually refer it out because it's a very messy process. But there's some things that we call being judgment proof to some extent, and we'll usually do some research on the people that we're about to sue before we sue them. And the thoughts we have are this. We call people judgment proof. If you have a tax lien for hundreds of thousands of dollars for unpaid taxes, me suing you is not going to change anything for anyone. I will not recover any money from you. If other people already have judgments for hundreds of thousands of dollars against you, you'll just be another judgment along the line of 20 other judgments. And we've seen them. There's people that unfortunately are unsavory individuals and they don't pay anybody back and they have judgments against them and there's nothing you can do. Another reason or another, judgment proof thing or category is that somebody could be judgment proof because they're married and all of their assets are in their wife's name. And if you get a judgment against one individual, you're not going to be able to collect on any assets that are owned by that individual and their wife.
I think that, Anton, this is a phenomenal thing to share because you're giving folks that information that they need. Like, look, you're an attorney. Your business is to get cases, right? And so we have a whole episode dedicated to the idea of, is it worth pursuing this, right? Because it's important to for the things you said, to filter out and vet what are the cases that are worth pursuing, what are the opportunities for damages that are worth pursuing versus the ones that maybe aren't. And that is going to make the difference from an experience when you're working with an attorney of turning back and going, that guy just took my money, that gal just took my money and let me run up a bill on something that I should have never pursued, versus somebody that cares about their brand, cares about the integrity, cares about ensuring that future for both your brand, right, and the client, of saying, is this the right move right now? Should we be suing or should we not be suing?
Yeah, and I think that's a good way to put a pin in it. But I think there's one other thing we should really touch on here before we finish up. When you're looking for a lawyer, what are you looking for? And one of the things that I think that we've kind of danced around is when you're a potential client looking for a lawyer, you're pitching your case to the lawyer. And so you should also, if you're not cognizant of what is your case worth, how much are you going to spend, how much are you willing to spend, you can potentially get caught up with a lawyer who's now pitching themselves to you. And they're not paying attention to these things. And so for us, we try to do the bigger cases. We try to do the business disputes. We try to do, the high value tort claims, as we talked about. So we try to stay away from these smaller cases. But there are a ton of lawyers that do focus on these smaller cases. And without talking trash about those lawyers, I think that you can have a volume business of doing just these, small claims or just these arbitrations and being in that arbitration room all day, every day, kind of like eviction lawyers are in those, in that eviction court all day, every day. And so there are lawyers that can make this work. And so what you should be doing as a client when you're vetting lawyers is part of it is you're pitching your case. So we talked in the first part of this is about how do you put together your case to pitch it? What analysis should you do? But when you're hearing the lawyer respond to you and saying, for instance, let's put myself into those shoes. We're really aggressive. We're going to pursue this on your behalf. We're going to do our best. You really should be questioning how much can this cost me? And how much, and are you the right lawyer to do it? Because I will tell you that I try not to be the right lawyer to do small claims cases just because it doesn't make financial sense for us or for you. And so then your question as the client to the lawyer is, well, am I paying you this money? Is there going to be more money? Am I paying you, $5,000 as a retainer and now we're billing against that retainer? So this case could cost $20,000. Right. Or am I paying you $5,000 to do the small claims case beginning to end?
Interesting. I really love the concept of and asking the question, because it really turns the vendor relationship on its head, right? If we ask the question, when you're hiring an attorney, who should be pitching who? Should you be pitching the attorney, or should the attorney looking for your business be pitching you? I love, Anton, that you're saying you should be pitching the attorney, because it changes the incentives to the degree that if an attorney is pitching you, right, on a smaller case, right? If it's a larger case, you're obviously going to need to pursue that. But when we're thinking about this in the context of, should I sue? Should I go to court? Should I do small claims? What should I do? And you're in there and the attorney's pitching you, there's something possibly off, right? They're possibly trying to just, get a case that maybe, again, there's examples where you're paying 10 to collect 12, right? Whereas if you're pitching the attorney and they're saying, hey, this might not be a good fit, you have somebody that has your best interest at heart, because if it's not that larger size case and there's a better pathway in a smaller case, you should be pursuing that.
Right. And also, it's so important to think about, how much am I out? If I'm out $5,000, $6,000, $7,000, $8,000, under $12,000, how much money can you realistically spend to recover it? And you should be thinking about, maybe I could do this myself. Maybe I could try the small claims avenue myself first and then go to a lawyer. Because we've just seen so many cases where it's so little money and they want to go through a lawyer. They don't feel comfortable to do it themselves. But we're almost saying, hey, maybe it's better for you to lose $5,000 than to lose $10,000.
I really like that, because it brings up a different question for me, which is a two-parter here. Number one, is there ever a good reason to bring an attorney to small claims court, right? And number two, if not, or if I choose not to go that route and maybe I don't perform I get nervous or whatever, is there anything I can do after that?
Two great questions. Let's address them both in turn. I think let's start with your second question, because the second question is easier to answer quickly. The first question is more in depth. With your second question, if you lose in small claims court, you can appeal. That's simple. And when you appeal a small claims court decision, it now goes to the next level, which is typically arbitration. And it's called de novo. There's this concept called de novo, which means anew. And so everything that was said and done in small claims court is irrelevant. It's as if it didn't happen.
That was going to be my next question. That's awesome. So there really isn't that much of a risk going into small claims court. If you're under 12, it sounds like you make that move, save the money, and do your best, and then appeal if you feel like it didn't go your way.
Yes. And I think, and we advise a lot of people to do that, especially when their damages are right in the $5,000 to $7,000 range. Because we say, look, we'd take a $5,000 retainer, or even if I had a junior guy do it,
right,
we'd take a $3,000 retainer. It's already half of what you're looking for. And then don't forget, the other guy can lose an appeal.
Okay.
right?
Yeah.
So you'll spend the $3,000, you'll win the $5,000, but he'll appeal. You still have to do it again, right? And
Totally.
so that analysis is really the small claim court. The way that it's set up, it's meant to help people try to facilitate small disputes and try to resolve them. We should stay on this topic for a little bit and maybe delve into another thing about trying to resolve your disputes before going all the way. But let me answer the first question that you had. Is there ever a reason to bring an attorney to
into a
claims
small
court?
claim court?
So companies will do it. An individual, maybe if you're just so scared of speaking, or maybe you don't speak English very well, or you need somebody else to be your voice. I could see an individual needing that. Like, for instance, we're Russian speaking.
Firm,
we have
right?
a Russian speaking
law
firm.
yeah.
We have a lot of our paralegals speak Russian, our clerks speak Russian, our lawyers speak Russian. So everyone speaks Russian, or at least someone at every level speaks Russian. And I've been in situations where the people I'm dealing with have very bad and broken English. So it might be helpful for those people to have somebody represent them.
Right. And in that case, do you go first and find like a friend that maybe speaks better English, or it's like at that point, are you worried about a little whisper down the lane? Is it really just more like, hey, if you don't speak English well and you don't have anybody in your network that's going to be able to support you in this, go to an attorney?
It's also, that kind of goes on a big tangent, but the answer to your question is, when you don't speak English very well, it's not just the speaking piece of it. It's the reading piece of it. It's the understanding the process piece of it. And so it's not really as simple as saying, well, I just need somebody else to talk for me. You need somebody else to really understand how the process works for you.
Got it.
And you need somebody else to read the documents that come in and understand, their context. So that makes it a little bit more difficult. So for that reason, that's one reason. For businesses, a lot of times, if you own a small business where you're, let's just say, a plumber or something, it just might cost you more money to be in that courtroom than it does for you to be out on the field.
Got it.
So you might pay a lawyer to be there rather than here. Right. So you could go do your job and have the lawyer do his job.
So in that situation, you don't necessarily need to be there. Just somebody needs to be a representative.
A representative would need to be there. You often would need a witness of some sort, because if you're going to introduce documents or evidence or, testimony, you need somebody to I can't testify on behalf of the client, but you could say, let's say you're a small business, you're a plumber, which is the example we used, and you're the owner, you have two other plumbers that work for you. And one of the other plumbers knows all the facts. And so you say, all right, I'm going to go do work because that'll make me more money than this small claims court will lose me. And I'm going to send a lawyer, and I'm going to send one of my other plumbers who's well aware of the communications and the facts. Let them handle it, at least at the first instance. And so that's one reason.
But if you're the solopreneur plumber, you got to come in that day because you're the one who has to provide that information. I was going to ask if
you might not even need a lawyer. You might be,
right now
well versed enough to, yeah.
But if you're this Russian speaking plumber that has broken English and you're by yourself, now maybe that perfect Venn diagram of everything. I will say, I was going to ask, and I think you kind of answered it, is, well, does it hurt you to not, like, if you were to just send the attorney, but it sounds like you can't, if you were to just send the attorney on your behalf, does it hurt you a little bit if the judge, in the judge's eyes or whatever, that, you didn't come, you just sent an attorney?
A little bit. Maybe it could. Right.
It could.
And the other thing is, and we didn't talk about the other example, is if you're a much bigger company,
right,
and you're being sued in small claims court, you just have no business being there.
Okay.
As the owner. So you should probably send a lawyer. But more often than not, and again, those are the clients that we typically have a relationship with, a business relationship with. And those clients will say, hey, we got this little thing, we need you to go handle it. And we go handle it as part of our relationship. So it's not me taking on a new client just to go to small claims court. It's, hey, we do all these other things for this client, and we'll go to small claims court.
So once this is part of your retainer, that might be an opportunity to send your attorney if you're a bigger company, bigger organization.
Yeah, and that's not who we're talking to today. We're talking to the people that, are an individual that kind of is out under 12 grand. What should they be thinking about? Or somebody that's out, 15 to 45 grand. What should they be thinking about? For the smaller businesses or for the larger businesses, you guys all should have an attorney on retainer. We could talk for hours and hours and hours about why it's a horrible idea to do some of these things yourself.
Yeah, that I mean, even just in this conversation, I feel like you can apply that and go, well, probably shouldn't do that myself. In those for larger organizations, is there anything else you feel like is a major takeaway or thing we should talk about in terms of this idea of suing, not to sue?
Settlement. Let's talk about settlement. I think that there is this concept of I'm going to sue you and that's it. And people, what they don't do is they don't take account of their damages. That's first and foremost, right? And so once you've taken account of your damages and once you've taken a mental note of what it's going to cost you to recover those damages, you should combine those, multiply them by the probability of recovering. You know, you could have AI do it at this point.
Yeah,
right?
I know you promised you weren't going to be a math scientist, I believe was the quote, but today you are.
But like the concept is, you know, what are my damages? What am I going to spend to recover these damages? And how likely is it 100%? It's never 100%. So, you know, it's at least, you know, 50 to 90%.
Right. If you're looking at a contract where it's clearly a breach of the contract, it's probably going to be higher probability. If you're, you know,
if you don't have a contract and it's he said, she said, and you know, you're mad that your coping is 1 inch to the right, you know, it's all of a sudden it's like these things aren't, you know.
It feels like when you're watching a baseball game and you see someone in the batter's box and they show you the analytics of the body. When they're up there, it's like all hope and joy, and then all of a sudden the first pitch comes in, they're like 40% chance of getting on base, 20% chance of getting on base. 5% chance of getting on base.
Right. Or Texas Hold'em, right? They start out with like a 70% chance of winning, and then just like the first card comes out, it's 30 now. It's like, sorry.
That's exactly right.
Right. So once you've done that kind of analysis, you should really think about this concept of A, how much good money am I going to throw after bad money?
Yep.
And B is what money would I take to be done right now?
Oh, I like that question.
And so you should be thinking about these things. And so when you're dealing again on a small claims basis or on a under 50,000, I mean, 50,000 is tough because, you know, it's not easy for somebody to write a check for $50,000 unless they're a huge company of some sort. But if you're talking about 5 to 7 to 15,000, somebody could write you 2 checks for, you know, 3,500, and it's, especially if it's a business and it doesn't destroy the business and it makes you whole. And even though you think you're owed 10, you accept 7 over 2 checks, everyone kind of walks away without having to spend any more money. And so the one thing that people don't really think about is settlement. They don't really think about settlement until they've spent more money, until they've gotten lawyers involved, and then the lawyers almost pushing settlement down their throat. They're saying, hey, well, you know, it's a 50% chance of you winning, and you're saying you're owed 20 grand, but this person's willing to pay you 16 grand, and you've already paid me 5, so like, what do you think?
Yeah.
Right? And so
when does that settlement analysis come into play? Because you just said a lot of people are considering it when it's too late, right? When is the right time, or when is the time that you should be considering that settlement analysis?
You should try to resolve things with the person that you're thinking about suing. I think at every step of the way. Frankly, it's like the poker analysis is a perfect one, because in the beginning you just have your 2 cards. I have we're talking about poker, Texas Hold'em.
Yep.
Just so everyone's clear, I have my 2 cards. You have your 2 cards, right? And so, you know, I have 2 kings. I don't know what you have, but I think my hand's like the best thing on earth right now, right? You could have 2 aces and I could not know it. And, you know, I already have a way worse hand than yours. So in the beginning, you should always be trying to work it out. But even after you filed the lawsuit, whether it's a small claims lawsuit or a bigger lawsuit, and we could use the analogy of the first 3 cards came out, right? I had these 2 kings, and now it's, you know, heart, heart, heart. And none of my kings are hearts.
Right.
And so now all of a sudden my hand's not so good anymore, because if you have 2 hearts, I'm dead in the water. If you have 1 heart, you know, the next card. So we should be talking. We should be trying to think about how to resolve it. And now, given there's people that have no interest of resolving it. There's people that are disappearing on you, that took your money and they're just gone. But in a business sense, businesses should always be thinking, what is the right move for me? And what is the right walkaway? And
how to resolve it. Yeah.
And how to resolve it. And listen, somebody might make a completely nonsensical offer to you. And they could say, hey, you know, I know that you think you're owed 12 grand. I'll give you $2,000. And a lot of people their emotion will flare up, and they'll say, you know,
you just gaslit somebody.
Yeah, I'm going to a lawyer. That's it. Maybe you should come back with 10,000 and see what they say. And so that settlement conversation should be had constantly. And as lawyers, what we try to do, and again, another analogy, is when we do discovery, and you use discovery, but now I'm talking about discovery in the legal sense. You give me your documents, I give you my documents, I do depositions. When we're doing discovery, what we're really doing is we're doing two things. We're either A, closing the door on arguments that you might be able to make, but now that I've gotten you to commit that that's not what it is, you can't make that argument anymore.
Got it.
So that's one, is closing the door. And two is finding the needle in the haystack, so to speak, or the smoking gun. That's this one super good fact, right? We talked about things that move the needle. Here's this one super good fact on which you're going to lose. If I show the jury this, they're going to believe me. They're not going to believe you. You lose. And so as soon as I have that fact, what I should be doing as a lawyer, and what you should be doing if you're doing this without a lawyer or before you go to a lawyer, is to hold this one document up and say, hey, look, when I show the world this, you're going to lose. So why don't we settle now?
Still coming back to that settlement, right? And it's a strategy that avoids a lot of additional costs. And again, I love the poker analogy. I think for fun, and I think that's something that's going to really resonate with people. And I think for fun, I want to really take that poker analogy and you use I've got, cowboys, 2 kings. I don't know what you have. You could have, aces, right? What if is there a scenario you can think of? And I'm putting you on the spot right now. You've got your pocket king. So think of cases, your caseload that you've had over the years, and maybe there's an example of this. You've got your pocket kings. It seems like pretty straightforward. I appear to have like a 2-3, but somehow that lands on the board. You gave the example of 3 hearts come out. I got these pocket kings, and they're useless now. What does that look like in real life? Like, give me an example of a case that you've, maybe done in the past, or
hundreds of them.
Okay, give me one.
Well,
where like it seems so obvious that I've got this win, the contract, the whatever, and then all of a sudden this other detail comes out.
All day. So in the contractor scenario, the individual comes to you, they say this contractor screwed everything up and they're not on time. They took extra money. They're saying I owe them all this extra stuff. Everything they did was wrong. Okay. So, we start we'll usually start with a letter of some sort. Sure. We send a letter. We say, we'd like to resolve this with you. Let's talk about it, kind of thing. And to your point, the flop comes out and the contractor sends 10 pages of text messages where this person is, today they want the wall green, but now that you've painted it green, they want it red. But they don't want to pay you extra to go buy new paint or for the time that you had to spend to paint the wall twice.
Right.
And so all of a sudden I'm just like, all right, well, my 2 kings suck now.
Got it.
Right. And that happens
all the time.
All the time.
Is there a case of where people are more self-reflective, but get a surprise? Like,
yeah, of course.
Like what's a situation? Because that's pretty clear. Like, you're looking now at these details and going, it sounds in this situation, not to make any assumptions, but this person was being unreasonable in terms of how they were working through the agreement. But what's an example where, maybe, I don't know if it works with our original contractor agreement, right? $100,000 backyard, $50,000 spent, contractor and homeowner are having this disagreement. Homeowner is pretty confident, maybe you can make something up or have, an example from prior. Like, what's something that's a surprise on that flop, right? Because that was where my head went is, I've got these kings. We have the agreement. We both signed it. And maybe it's something like, oh, you didn't put the right jurisdiction in the agreement, or you didn't double check. Like, maybe it's something that's like one of those technicalities.
It's so hard. It's so hard to kind of make up an example. But I'll tell you this, and we could talk about screening clients and what you should think about when you're talking to a lawyer for days, frankly. And I don't think it's enough time here today. One of the best questions that I've learned to ask is, what are they going to say you did wrong?
I love that. Yeah.
And if you really, and again, now put yourself into the shoes of the person that's calling the lawyer to try to explain the story. Put yourself into the shoes of the person you're threatening to sue. What are they going to say you did wrong? Why are they going to say they did what they did? And look, in some cases, it's completely unredeemable. The person stole your money, and that's open and shut, right?
Right.
But there's some cases where you think that they did something wrong, but you're not really grasping or not being, self-aware of their side of the story, and you're just kind of knee deep in your side of the story. And we as lawyers, we see that so much, and it's really hard to deal with And you really have to, as a lawyer now, screen for it because, again, you could be halfway into a lawsuit before you realize that your client lied to you.
Right.
Or that your client, maybe they didn't lie to you. Maybe it wasn't, intentional. Or your client maybe just didn't understand the contract. Or maybe your client didn't understand what their obligations were. Or maybe your client, was indecisive and didn't realize that would cost them more money. And there's so many different things like that pop up that it's so hard to just nail one down.
I imagine that there's a whole subset of folks that don't have a ton of experience in the legal space, hopefully, fortunately, right? And then they're encountering this situation. They go to an attorney, and all of a sudden they feel like the attorney's grilling them, right? You're supposed to be supporting me. Why are you asking me all these questions? Right? And I think that it's a great mindset shift for folks to have when they're walking into that situation to go, my attorney's job is to represent me. And the best way to do that is if they can take both sides of the story and meld it together into a story that benefits me, right? The probability is not 100% of winning in most of these cases. And that means that there's gray area. And if there's gray area, that attorney needs to know how to navigate that gray area. So if you're going into the situation emotional, stressed, you're going to your attorney going, this is what I need you to do, and this is how I need you to do it. I think that if you're already entrusting the attorney with your case, you need to entrust them with how they represent you. And part of that is vetting the person. Now, I think the reverse side of that I want to mention is if your attorney's not doing those things, if your attorney's not asking you tough questions, if the attorney's not making you put on our, pretend thinking caps and pretend we're the opposite party and what are they going to say about you, if they're not asking you those questions, that should be a red flag that, hey, this person may not be as concerned with closing this case up quickly, or just may not be that great at what they do. And it is what I'm getting from this.
I think we call them good facts and bad facts. Mm. And I think that people are really hesitant to tell their attorneys the bad facts because they're afraid that either the attorney won't take on the case or that the attorney's going to do a bad job because they now know this. Mm. And I've been in situations where I find out the bad facts from the other side. And so there's a lot to be unpacked here. Number one, we are not criminal attorneys. We are civil attorneys. So I want to know the bad facts. I want to know if you did it. Right? I'm not talking bad about criminal attorneys. I love criminal attorneys, but
they have a different responsibility. I think there's nothing negative about that. It's in that situation. There's, I guess, a different approach to how they're
and I'm not saying that's
cases.
Even their approach. Right. I'm just saying that I want to know the bad facts, and there's a couple of reasons for that. Number one, when you are at the end of the road and you're in front of a jury, right? Assuming you have a big, huge, super huge case, it's $1 million case, you're not going to settle it, you're going to go to a lawyer, you're going to sue, you're going to do all this stuff. When you're in front of a jury, there's two huge things you have to think about. Number one, people can see right through you. You might not think that they can, but they can, and they might not know that they can, but they get a feeling about you. And especially when you're sitting in front of 8 jurors or 12 jurors, those people see right through you. And so if you're hiding the bad facts, they see through that. They might not consciously know that they're seeing, but they know that there's something off about you. And they know that there's something off about what you're saying. And if the other side knows that bad fact, they are going to rub your nose in it so hard. And then after you're done presenting your case and they start rubbing your nose in it, now you look horrible.
Right. It's much better to be able to have addressed it.
So you lead with the bad facts. That's what I'm getting at. You have to acknowledge that you have bad facts or a bad fact, and you have to say, look, I know that I did this wrong, or I know that this doesn't go in my favor, but look at all of these other things that do. And think about...
It's like Eminem in 8 Mile. That's how he wins the rap battle. He opens with the bad facts. This is everything you're going to say about me. But I'm still, but I still have a case.
Great life lesson. That's exactly what it is, especially when you're in front of a jury, and even more so when you're in front of a judge. Because and I've been there so many times. So there's a jury trial, right? That's when the jury of your peers decides your fate, and then there's a bench trial when the judge decides your fate. And so a jury is 12 individuals or 8 individuals. Some places use 6. The jury looks at your case, and most people that are a jury are, regular folk that don't spend all day listening to disputes and don't spend all day, with the law and resolving it. So you might be able to slip something by them. You're not slipping something by the judge. The judge looks at you because the judge sees this story that you're telling all day, every day, for years, literally. And now you're the guy that's going to tell him a lie that he's not going to see through.
Right.
You got to lead with the bad facts. You got to know how to answer the bad facts. And when you're talking to a lawyer for the first time, if you have a bad hand for whatever reason, you should be upfront about that, because lawyers will also become disenfranchised with you if you've lied or concealed something that they then find out about after they've spent a bunch of time and money and effort on your case. It's like, well, why didn't you tell me this on day one?
Well, I imagine too, there's a little bit of, and I don't mean this in a negative way, but there's a little bit of ego. You want to win. And if you're taking on a case, right, you want those wins to be higher than your losses. And so if you're being hamstrung by your own client, keeping things from you or not being fully honest, it's like, yeah, you might be a little bit frustrated. And now you're creating this whole paradigm where you don't have a good relationship with the attorney potentially. And I know that you might say, well, I'm hiring him. That's his job. Figure it out. But we're humans, and that's part of it, right?
But
and, yeah.
That I'm hiring him, it's his job, figure it out. I need to know so that I could figure it out.
Right.
Right. And it also
Mom
goes
spaghetti.
It also goes towards settlement. It goes towards settlement. So if I know that there's this bad fact and maybe they're not aware of it yet, but eventually they're going to become aware of it, that should guide you towards settlement. You should probably want to settle this case before they have an opportunity to rub your nose into that bad fact.
So that you can walk away and your client can walk away and say, hey, we had this bad fact. Folks at Kaminsky Law knew it, so they were able to navigate me to the right course of action to either maximize my winnings or reduce my damages, right? Because that could be the other way that we're doing this, right? You're bringing an attorney. Maybe you are in a position where something did go wrong, and there's this I don't have a better way of saying it. There's this come to Jesus moment that's about to happen to you.
Right.
And you can reduce damages. And that maybe is another way to think about what you're doing with an attorney.
I think the great way to think about it is attorneys used to be called counselors. And, I'm trying to counsel you on what your situation is. And I am often trying to act as a neutral person. I am on your side. But I am trying to put myself into the shoes of a neutral person. I'm trying to put myself into the shoes of your adversary. And I'm trying to counsel you on how we should approach this. And I think when you're talking to a lawyer, when you're thinking about hiring a lawyer, these are the types of qualities that you should be looking for. You should, especially with bigger cases, right? With the smaller cases, you win, you lose, not a huge deal. But with the huge cases, with the real things that move the needle, the things that matter, you really want to look for somebody that's not only aggressive, but is also going to be real with you and is going to be upfront with you. Because I've seen lawyers that will, sell you the fool's gold. And after they've sold you the fool's gold, they will act like, you're going to win, buddy. I got you. Right. And it's, at the end of the day, I don't know how they hide their tail, but they show up and say, sorry, I guess we were wrong. But my brain can't handle that.
Right.
And so
you as an attorney, to that degree, you're being paid whether you win or lose, right? You are contractually, with none of that retainer, you're spending your time and hours and doing your best. And that's a good faith thing. And so if someone's, again, all the red flags, all the things that we've talked about today, if you're not seeing those, or if you are getting, it's either if you're not seeing them from your attorney, that's a concern. If you are getting them from your attorney, don't take them with disappointment, right? Appreciate the fact that this is the process of getting the best outcome.
And that's what you're paying for. You're paying for your attorney to be upfront with you. Look, there's going to be cases and situations where you have a situation and you need somebody to get you out of it. Right. And you also want an attorney to be upfront with you there. Like, hey, man, if you lose this, if you go in front of a jury with this, you're screwed. Right. We're usually we've been talking about cases where you're on
trying
offense.
To win. Right. The entire thing is win or losses. But now we're kind of shifting into reducing damages.
And I'm also saying, like, when you're on defense, right? When you're on defense, you should also have somebody that can counsel you and say, look, man, you're in a tough pickle here. And I could spend a fortune of your money defending you. but there will be an end of the road. And at this end of the road, you are screwed.
Yeah.
So let's think about how to solve that.
That is a great note as well. And I think that I think overall, if I was to sort of summarize what we talked about today in the concept of to sue or not to sue, I think the word counselor comes to mind. And I think that the idea is that when you're hiring an attorney or you're vetting an attorney or you're pitching your case to an attorney so that they can vet what you should do next, that process of counseling is what you should be seeking, because that's where you're going to get the advice that's going to lead you down a path that's either going to win a case, settle a case, reduce damages for something where you might be in the wrong, and finding the right attorney, trusting in them in that counseling, I think is maybe the core to everything we've been talking about today.
So you have to trust in your attorney. You got to be forthright with the facts with your attorney. You got to be real with yourself about what your damages are and what your chances of recovery are, and that'll get you the best results.